Alright, for those that don't know me, this is King U, the world famous political prisoner. And today's lesson is about the methods in which white supremacy is being enforced right now. For those who don't know me, John W. Dobbs, DC number C00618, serving a life sentence right now, taking this time out to do my part in the struggle. When they say that the revolution will not be televised, a lot of people don't know what that means. That just means that it's not going to be promoted. That means that when revolutionary things take place on our behalf, they're not going to be promoted, and a lot of times you won't hear about it, and you might think that nobody's doing anything about it. But right now, what I'm about to do is break down how they could convince a jury to convict a person without evidence. A lot of people don't understand that. They think, hey, you got family members out there, you got people who you love who claiming they're innocent or they shouldn't have got so much time, and a lot of people don't understand how these things take place out here in these courtrooms, and why there's so much police activity in your neighborhood, and all these things that's dividing our family, belittling the strength of our family and oppressing us, is actually causing more of the behavior that people are saying is the reason why they're locking us up. You know what I'm saying? Or, we need all these police out there because they're out of control. Well, we're out of control when you're taking the people who teach us control, like the fathers and the mothers, and the relationship, and you're distorting the relationship and stuff like that. So, and you're separating them, you know what I mean? So basically what I'm about to break down to you is what's called jury instructions. It's what is read to the jury after all the evidence is presented in a case, okay? In my case, a lot of people might not be familiar with it, but there are a lot of you who are. So I'm gonna say like this, okay? I got locked up for fighting 5 dudes who approached me and my ex-girl at my vehicle in an attempt to get her to take her from me. Basically, we was outside of a strip club. We had went to a strip club, okay? So during the process of the fight, I get hurt. I get cut about 6 times. I put 3 of them in the hospital and 1 of them dies. They gave me the max. I got more time than El Chapo right now, okay? And the evidence was all in my favor. Most of the testimony that these guys gave, they were so busy trying to protect themselves that they didn't, realize that they didn't understand also that I was the aim for the conviction. So they was trying to cover themselves, so they act confused. And a lot of times they said, I don't know who started it, I don't know what happened, I was just helping a friend. Okay, or I came over and attacked him after I saw him doing this to my friend, but I don't know who started it. So they're not really saying that it was a legal act that they, action that they took by attacking me. They're not saying that because they're saying they don't know who started it. I'm saying it was self-defense from the beginning. I'm saying I was protecting myself and my woman at that point in time. You understand what I'm saying? So, that means that under the stand your ground law, which implies it was a year old, and this is before the Zimmerman thing, but it was a year old when I caught this case, okay? I was in Florida for a day and a half. I was the only African American involved in the fight, okay? So you might see a lot of, promotion about my case in different magazines and stuff like that. My mom, she's been putting forth a hell of an effort, and there's a few other people who, who've been doing their thing. So, but this is basically for the ghetto youth, the homies, the people who's likely to find themselves in a position where they're dealing with this level of corruption in the system. And I'm going to show you just how corrupt it is, because like I just told you, these people said certain things, and then those things actually prevented the court from being allowed to prosecute me once I said it was self-defense, because they never said that I started it. For the first 2 months, nobody said I started the fight. As you see, George Zimmerman was not locked up initially because there was nobody countering. There was no counter argument to what he was saying. It took a lot of people to say, hey, look at the evidence, this, that, and the other, and you know, give him a trial. You know what I'm saying? So righteously, I should have never been arrested, and my detainment was illegal, and still is, and it's been 17 years. Okay, check it out. So right now you're talking to the convicted murderer, all right? But I am not a murderer. I killed the man in self-defense, and I'm gonna break this down to you. Okay, I'm gonna explain to you the stand your ground law. Okay, as it was in 2006, 2007. You know, when I was going to trial on this thing. There's different levels of homicide. Now, if you see right here, this right here is going to say jury instructions. I know it's going to get a little boring or whatever, but this is something that you really need to know, because you need to be aware that when you go into a courtroom, these type of things, these type of errors is going to be taking place purposely to railroad you, and nobody's going to understand what the fuck happened. They're not going to understand. They say, hey, they didn't have any evidence on them. How the hell did they do it? And then they're going to think that you're lying. They're going to think that you're lying by saying this, and they're going to be like, well, you're hiding the truth. You're not telling the truth. There's something that we don't know. They ain't going to do this to you for no reason. Okay? They'll do this to you. This is called selective prosecution. In my case, nobody was arrested but me. Okay? And nobody said that I started the fight. Okay, so there's no reason why I should have been the only one arrested. Matter of fact, the first guy in the fight, he was actually on probation. In the state of Florida, being on probation means that you're automatically going to be locked up for any police contact. Okay, he was out past his curfew, admitted to being drunk and being in a public brawl. Those type of things automatically is a violation of probation in the state of Florida. But they didn't violate this man's probation. Okay, they didn't do anything like that. They arrested me, and they you know, we're gonna get into a lot of that later on. But right now, I'm gonna explain this these jury instructions. These jury instructions. Okay, right now I see everything is being backwards. So what I'm gonna do, I'm just gonna explain it to you. Okay. The first thing. The Stand Your Ground law back in 2006, 2007 was 776.013. That's where it was at. A lot of people say Florida doesn't have a self-defense law. They don't call it a self-defense law. They call it a justifiable use of force law, because it encompasses more than self-defense. So don't be fooled. There was always a self-defense law. Prior to the Stand Your Ground law, though, you had to retreat. You had to show that you didn't want any part of the violent activity initially, okay? And this is what they took away with the Stand Your Ground law, which read 776.013 specifically read, anyone who is not engaged in an unlawful activity and who is attacked in any place where he or she has a right to be has no duty to retreat and has the right to stand his or her ground and meet force with force, including deadly force, if he or she reasonably believes it is necessary to do so, to prevent death or great bodily harm or the commission of a forcible felony. A forcible felony could be a robbery, you know, somebody getting ready to break your car window, destroy your property, things like that, but a forcible felony, okay? So it doesn't just mean that you have the right to stand your ground and use deadly force against somebody trying to kill you, okay? Now, I'm saying that because I want you to get clear in your head that this is why you've seen cases where somebody was approaching somebody in a threatening manner and that person would shoot them in the head and they'd get off for shooting them in the head, because under this law, if it's reasonable for you to believe that it's necessary to prevent death or great bodily harm, like somebody knocking out your teeth, cutting you, you know what I'm saying, busting your nose, you know what I'm saying, these type of things are considered great bodily harm. Matter of fact, the charge that you would get for doing this for committing such acts would be something like battery, Okay, now they gave me the max on everything, even though the guy who died in the fight was proven to be the third or fourth guy in the fight. Even though he's the person that I spoke to prior, he was the third or fourth guy in the fight. So I was fighting 2 or 3 guys before this guy even got into the fight. And the judge knows this. And there's no evidence. Nobody's saying that they saw me do anything to him. I'm telling you what happened. I'm telling them what happened. I'm saying, yeah, I did stab him. I stabbed him as I was fighting 3 or 4 other guys, right? And you can see that I was cut, so they cut me several times myself. You know what I'm saying? And these guys were all bigger than me at the time. You know, I was in Florida for a day and a half. I'm from New York. I had a crib in Atlanta, well, on the outskirts of Atlanta in Marietta at the time. You know what I'm saying? Me and my ex, we was coming out here to visit my kids from a previous relationship, and we were planning on heading home in the morning if things would have never turned out the way they did. You know. Yeah, I'm from Southside Jamaica, Queens, for those who, you know me from around there, you know what I'm saying? Shout out to everybody over there, you know what I'm saying? So, yeah, and I've been out here with a lot of these dudes out here in Florida for a while, and I've been seeing how they've been getting railroaded. I'm sitting here like, damn, you know, so, you know, I studied this law stuff. I know what is going on. I've been doing it for years, you know what I'm saying? I mean, really hard for the first 15 years of my bid. Now, I slowed down a little bit now because I see that, you know, no matter how accurate my arguments have been, they've decided to blackball me and decided that they're not going to answer any of my statements on the merits. They're not going to debate it. They're going to say that I've been locked up so long that the time has expired, which is a false claim, because more than one of my issues, such as subject matter jurisdiction or fraud on the court, can be brought up at any time. You know, not regular fraud, but fraud on the court. Fraud on the court means that they are, the fraud was to the extent that it calls into question the integrity of the proceeding itself, okay? Or that it prevented my participation or the defendant's participation from being effective. You know what I'm saying? So when I said it was self-defense and nobody said it wasn't, but then you put in a document saying, hey, we're saying that he's being charged like this because somebody said that, you know, things that amounted to this crime, which nobody actually said. That's fraud. It's on the court. It's fraud on the court, and it also prevents my statement from being effective now, because now it's countering my statement when there was nothing actually tangible that countered my statement. But let me get back to this jury instruction. Like I said, in the stand your ground law says, if he or she reasonably believes it is necessary. Okay, I'm going to that point because even my public defenders were part of the strategy to imprison me, despite the fact that I would have been considered a hero if I would have been of any other race, okay, against any other race. You understand what I'm saying? I mean, I'd have been on Oprah, or they'd have been Andrew, how does it feel to survive the attack? You know what I'm saying? I'd have been sitting on the couch. I'd have been having people sitting there, you know, coming out and, you know, congratulating me and saying how brave I was or whatever and all this type of stuff. This is the usual reaction to an American standing his ground against, you know, forces of evil. You know what I'm saying? But I'm considered the force of evil because I guess I'm the ghetto youth. I'm the ghetto child out here, and this is a state that's been bent on the oppression of African Americans. And it's sad because we've contributed so much, you know, positivity that they will not allow you to look at. Well, they would not make it easy for you to look at. Anyway, my public defenders requested a specific jury instruction, and usually it's titled duress or necessity. Okay, I want you to pay attention. Now, this is, you know, this is something that you're gonna have to go over and over again. You're gonna have to look at it, watch it again, watch it again, watch it again, because there's so many things that you're gonna miss. There was so many things that I missed. Okay. Sorry for that distraction, and sorry that it's taking so long. You know, I'm not a professional performer or nothing like that. You know what I mean? I just do what I do, You know what I'm saying? Hopefully you guys get an opportunity to learn from it, and hopefully it saves some lives and some families from being destroyed. Pay attention to the jury instructions, okay? Despite the evidence that I just told you exists, and I'm going to show you, and as I have showed you in other videos, I'm going to show you that, you know what I'm saying, they can still convict you. And it's because what they'll do is step on the law. If they do put the proper law in there, they're surrounded with other laws that'll be distractions. Okay, like I was saying, my public defenders requested an instruction called duress or necessity, but they titled it strictly necessity. Okay, this is let me see if I can. Okay. Okay, I got convicted of second-degree murder, right? So I'm in here, I got a life sentence for second-degree murder. You know what I mean? And I just told you the circumstances, so there's no reason that anybody should have took it to the max. I could have got 22 years. You know what I'm saying? If there was any type of reasonable sense of responsibility, or even, like confusion. If there was any confusion, like, okay, we don't know if he really did that, it wouldn't sentence me to the max for killing somebody who's the third or fourth guy to be attacking me, okay? Anyway, so it says an issue in this case is whether or not John Dobbs acted out of necessity in committing the crime of second-degree murder or manslaughter, all right? So now, pay attention to that, okay? I'm going to go, there's 6 elements. It is a defense to second-degree murder and manslaughter if the defendant acted out of necessity. In order to find the defendant committed second-degree murder or manslaughter out of necessity, you must find the following 6 elements. First of all, let me tell you what's wrong with this instruction for my public defender to be given this, to be requesting it. It says that second-degree murder or manslaughter was committed for a fact. So that just wipes out my whole defense of self-defense, saying that, hey, I acted in justifiable use of force. There's different levels of homicide. Excusable homicide, justifiable homicide. There's manslaughter, as you can see, and this is one of the things. There's several errors that they implemented in my jury instruction to defeat my defense. And this right here was offered by surprise, because we had no discussion on this. My public defenders didn't say, hey, we plan on asking for a special jury instruction or anything like that. This just popped up on my trial, and when it was coming in my head and I was receiving it, it was over my head. I didn't realize that, I thought it was making a little sense. Number one, the first element says the defendant reasonably believed a danger existed which was not intentionally caused by the defendant. Okay, yeah, I said, okay, well, yeah, I don't disagree with that. So then, okay, the second part said the danger threatened significant harm to the defendant or third person. Yeah, the danger that they caused, threatened significant harm to me and my ex-girl. Okay, the threatened harm must have been real, imminent, and impending. Yeah, I got the wounds, I got the busted lip, I got the cut in over my eye, my arms, my hands, I got all these injuries, so I'm not seeing the damage that this is causing. I didn't even realize that it was saying that I committed these things for a fact. So now there's no question in the jury's mind on whether or not second-degree murder was committed. Now it's a matter of whether or not second-degree murder should be forgiven, which second-degree murder has elements of its own, okay? And none of them would, except for the fact that somebody died, would, none of the elements of the acts that I actually did commit in defending myself and my ex, would have amounted to the malice or the depraved mind that they consider to establish second-degree murder. Okay, now this is where it gets a little tricky. Okay, number 4, the defendant had no reasonable means to avoid the danger except by committing second-degree murder or manslaughter. Second-degree murder or manslaughter, when you're in the heat of a battle, that's not a second-degree murder, first of all, one. Okay, and manslaughter is normally when the odds of what you're doing is likely to cause the harm. Okay, not when the odds of what they're doing to you is likely, like, if I would have died, it would have been manslaughter on their part, okay, or some type of felony homicide, okay, but the slaughter was against me. So how I'm going to be, it's not going to be manslaughter. It's going to be self-defense. It's going to be respected as self-defense anywhere in the world for any other race or nationality under the same circumstances, okay. Like I said, and it says that, second-degree murder was committed. Number 5, the second-degree murder or manslaughter must have been committed out of necessity to avoid the danger. Now, they're calling this a necessity instruction. So that means that everything that I said prior about the stand your ground law, about anyone who is engaged in unlawful activity has the right to stand his ground. Anyone who is not engaged in unlawful activity and is attacked in any place where he or she has a right to be, has no duty to retreat, and has the right to stand his ground and meet force with force, including deadly force, if he or she reasonably believes it is necessary to do so to prevent death or great bodily harm to himself or herself or another, or to prevent the commission of a forcible felony. Like I said, you're going to have to go over this over and over again. You know what I'm saying? But it's worth it. You see how it says if he or she reasonably believes it is necessary. Now they seem to be defining what's necessary under this platform of what would be called duress and necessity, but they took the word duress out and they're just using necessity. So now the jury's going to be locked into this to find out whether or not they agreed that I acted out of necessity. And this right here is an instruction that really applies to, let's say somebody's getting ready to blow up a gas station and you see it getting ready to happen and you shoot him in the back of the head. Now that's a murder. You understand what I'm saying? But based on the fact that you're saving more people than, okay, matter of fact, it says it right here. Number 6, the harm the defendant avoided must outweigh the harm caused by committing second-degree murder or manslaughter. So now, when they say that the harm the defendant avoided, they're saying that I must have avoided a crime being committed against me that outweighs second-degree murder. Okay? Now, what outweighs second-degree murder? Only first-degree murder. First-degree murder outweighs second-degrry murder. So now I have to prove that these guys had a premeditated design to kill me, rather than that the force they was using was deadly, or that, it could have killed me, or that it was a forcible felony, you know what I'm saying? You understand what I'm saying? So they took away my right to defend myself against all of the things that stand your ground allows you to defend yourself against, except for first-degree murder, which was not what I was going out to prove. I didn't say, hey, these guys, said they were going to kill me. You know what I'm saying? I'm saying that the force that they was attacking me with was force that I had to use deadly force to overcome. You understand what I'm saying? Which I have a right to under the stand your ground law. Okay? So bam. Yeah. So let's say somebody's getting ready to blow up a gas station. So you shoot him in the back of the head and you say, hey man, look, I got it on camera. He was getting ready to blow up this gas station. Everybody in here would have died. Yeah, it was a murder that I committed. But the harm that was avoided outweighed the harm that I caused by killing him. You understand what I'm saying? Or let's say there's a prostitute and she's out there and she's selling her body and she gets caught and she's actually prostituting and they find her and she says, hey, listen, I did this because there's a guy that got my kids hostage or something like that and is threatening to do this to my kid if I don't do this. You know what I'm saying? So now she's guilty of all of the elements of prostitution. You understand what I'm saying? And she's not denying that, but it was out of duress or necessity, so the jury could still find her not guilty. Okay, bam. But in this situation, as I showed you, I would have never been found not guilty because of the simple fact that one is saying that the crime was committed, which is, I'm saying that it wasn't a murder. You understand what I'm saying? I'm saying what I did was in self-defense. Okay? So we got that, right? Hopefully, we might go back to that, but hopefully you guys understand that, okay? There's another instruction. Now, this is an instruction that the state itself has actually said was fundamental error in cases. And what they have is like, sometimes, you might be going to trial with something, and then the issue never goes to a court, and the court never decides the issue until after you've been convicted and that issue happened. And now you have to wonder if the case is going to be retroactive. Retroactive means that when the court makes this decision about how to interpret this law as flawed or error or whatever. You know what I'm saying? Like in Florida, they say fundamental error. In the feds, they say plain error. That means that it has to be an error that, you know what I'm saying, is clear for anybody to reasonably perceive as an error that will cause confusion and take away a right. Okay, so check it out. It's like this. The jury instructions on manslaughter, when I caught my case, it said that the jury had to find that I intentionally caused the death of William Troy. Okay, this is the man who is deceased in my case. Now, it says that I have to intentionally cause that. Now, second-degree murder does not have intent. So what that did was cause it to be harder to find me guilty of manslaughter than it was second-degree murder, because, you know, manslaughter, the elements was equivalent now to the elements of first-degree murder, which means that you had to intentionally cause, you know, the death of someone. Okay, so basically, it deprived the jury of the right to find me guilty of manslaughter if they felt that I was supposed to be held accountable for some type of, you know, to some degree, as far as it goes. So basically, they found that was misleading juries, and anybody who had that jury instruction was allowed to go back to court and have a new trial based on that. And most of the cases that in America actually that are overturned are the result of improper jury instructions. Okay, so they were allowing new trials, but it wasn't retroactive. That means that it didn't apply to everybody. It only applied the way they had it for those who were in the pipeline where their case was pending at the time that this case was decided. And the case that I'm talking about right now is Montgomery versus State. Okay, it was in 2009, and then it was appealed by the state and the Supreme Court of Florida. Affirmed the finding that it was fundamental error in 2010. Okay, so my case was actually pending for 8 days. I'm in the pipeline. I meet the category to have a new trial automatically based on the fact that my case was pending for 8 days, because in Florida, what they have is they issue a mandate. So they might deny you on this date, but the denial is not final until the mandate is issued, which is normally about a month after the denial, which gives the court a time to fix whatever errors. So even though my case was denied before this case was ruled upon, before Montgomery was ruled upon, even though my case was denied before that, my case was still pending. And it was pending, like I said, because the mandate was not issued. Okay, so I'm in the pipeline for 8 days. Now, I sent this argument into the DCA, where normally, most people would have got relief, but I'm not getting the relief because my case is so political. Okay, that's it. Bottom line, I'm entitled to a new trial based on their laws. Boom. So I just explained that. I'm not sure if you understand, but what it does is it makes it harder for the jury to find you guilty of the lesser included offense, because manslaughter is supposed to be a lesser included offense, and it only holds up to a maximum of 15 years in the state of Florida at that time, at least. So the point is that it made it where the jury had to find you guilty of a crime where you could get life, and they said that was unfair. Okay, now so I got that in my jury instructions. Let me see if I can show it to you. It's kind of backwards. You're going to see it backwards, but I guess I'll try to flip it around later on and show you. You know what I'm saying? Right now you're going to see it, and you're going to see that I have this instruction in my jury instruction. You say this is manslaughter, and yeah, we're going to go back to this later on. But that's what's up. Okay. Also, another error that they found is it's in a case called Talley versus State. And in Talley versus State, they said that an extra comma in the stand your ground law and the jury instruction, like I read it to you before, I said anyone who is not engaged in an unlawful activity has the right to stand their ground and is attacked in any place where he or she has the right to stand their ground and meet forcible floor. Let me see. Okay. Yeah. Anyway, right now I'm going to show it to you again. It's going to come out backwards because I got the camera facing me so that I can see what's going on. But you're going to see that there's 3 commas in mine. There's supposed to be 2 commas or one or 2 commas, but there's an extra comma, and that comma the court has interpreted to that it makes the jury believe that the defendant didn't have the right to defend themselves against non-deadly force, because the way the comma is structured, it makes them believe that you only have the right to stand your ground against deadly force, which, as I said, including deadly force, okay, is one of the aspects, not necessarily that it is excluding any other force, okay? It's to prevent death or great bodily harm, you know, or the commission of a forcible felony. Great bodily harm, like I said, could be somebody knocking out your teeth or something like that. So yeah, I have that, and they decided that was fundamental error. So that entitles me to a new trial, and that was applied to each and every one of my charges as well. Okay. Now there's another instruction. Now, it's the second half of the forcible felony instruction. The forcible felony instruction in self-defense cases was done away with the first part because they said it was confusing because it was circular. It makes the jury believe that the harm that you did is the same harm that, you know, prevents you from being able to have the right to defend yourself, because they're calling that harm to be a forcible felony itself. Okay, so what I'm saying is, like, let's say they say, okay, what they're saying is you have to have a independent forcible felony. Okay, it has to be a robbery or something like that for it to apply. Okay, for them to be able to say that you can't use this force, and it takes you back to the law prior to the stand your ground law. You know what I'm saying? They're saying that, you know, let's say it's an armed robbery, and or it's a robbery. You're robbing somebody, and then, you know, you're getting away, and then they hunt you. They chase you down and start beating your ass and this, that, and the other. And then you hurt them, and you say, hey, I hurt him in self-defense. Okay, I wasn't trying to hurt him when I robbed him. It was something, I just stole this and I ran and whatever. So you can be found guilty of the robbery and at the same time not guilty of the violent act against them, based on the fact that that part was committed in self-defense, because they took the law into their own hand, and you showed that you didn't want any part of the violence. You retreated, or you showed that, hey, you didn't have no intention to harm them and this, that, and the other, and, you know, they pursued this, and then you had to defend yourself. You're not just going to let them kill you because you stole a pack of batteries from them or whatever the hell. You understand what I'm saying? So this is the law. So these things get complicated, but you need to know these type of things to be able to defend yourself, because these are the type of things that will run circles around your head and have you in prison for 17 years like me, fighting for your life. You understand what I'm saying? And in a situation where these people clearly know the laws that apply and your rights to defend yourself, okay? But they don't support it. They don't support anything that would even give the hint of what would be considered by some to be black strength, or you know, equality or whatever. You know what I'm saying? So basically, there's 2 parts. The second part And that was the forcible felony part, but the law is the same. The second part is the part that they've been implementing, and it says, let me get the exact words that it says. A person is justified in using deadly force if they reasonably believe that such force is necessary to prevent imminent death or great bodily harm to themselves or another, or the imminent commission of a forcible felony. However, the use of deadly force is not justifiable if you find the defendant initially provoked the use of force against himself. Okay, now it says that means unless the force asserted toward the defendant was so great that the defendant reasonably believed the defendant was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger. And this is what I was just explaining, okay? Or in good faith, the defendant withdrew from physical contact, and and indicated clearly to the person who he was defending himself against that they wanted to withdraw and stop the use of deadly force, but the person continued or resumed the use of force. Okay, but like I said, initially it starts off with, however, the use of deadly force is not justifiable if the defendant initially provoked the use of force against himself. Now, if you don't define if you don't define provoked, you know what I'm saying? It can be taken in layman's terms. Some people might take standing your ground itself as provoking someone. Your girl might say, "Hey, babe, these guys are talking crazy, but hey, babe, don't stand there, don't provoke them. Let's go." You know what I'm saying? Now standing there and standing up to them is, in layman's terms, can be considered provocation. Under the dictionary, it'll say provoke means to irritate or annoy. So you're saying under this law, the way that it's being interpreted possibly by the jury is that you can't irritate or annoy the person who's attacking you, otherwise you lose the right to stand your ground and to defend yourself, and you have to retreat or show that you didn't want no part of it. You got to go through all these things, but this is not what the stand your ground law says. Okay, so this is something that's being implemented, and when we argued it, when a lot of people I noticed argue it in the court, in the DCA, in the appeal courts, they say it's an initial aggressor instruction, and they define it as initial aggressor instruction even in the book on jury instructions. But when they give the instruction, actually, they're not telling the jury that it's initial aggressor instruction. They're just saying that it's if they initially provoked. And provoke can be interpreted, doesn't mean it's not synonymous with aggressor at all times. You understand what I'm saying? So these are the tricks that are being played, and the jury will believe that they don't have the right to find you not guilty based on these laws which I just described, stepping on that stand your ground law, which, this is something that you'll notice in probably a lot of minority jury instructions. You know what I'm saying? But you probably won't notice it in a lot of other. I bet you it was not part of George Zimmerman's jury instruction, that whether or not he initially provoked it, because he followed the man. He followed the young man, and if anything, they would have found that he initially provoked it. You understand what I'm saying? The confrontation between them. I know that wasn't part of his jury instructions, but it'll be part of mine and it'll be part of yours. Okay? So, anyway, you know what I'm saying? That's today's lesson. Anyway, love, you know what I'm saying? Woo, all the homies, you know what I'm saying? East Side, you know what I'm saying?